So welcome to Module 9, Part 2 of Usury Preemption. And in this module, we will talk about what is included in interest as well as state banks' usury preemption. So as you'll recall, in the last module, we learned that under the Tiffany case, national banks can choose the best rate authority in their home state, and based on the Marquette case, they can export or charge that rate to consumers or businesses in all other states. So they only have to comply with the usury rate in their home state law. And as we know now, this means that when a state regulates the rate of interest, what they're regulating on bank loans is just the rate that the banks chartered in their state can charge. A state cannot restrict or impact the rate that out-of-state banks charge their residents. So that was the situation for a number of years until we get to the Smiley case, which was ultimately decided in 1996. At that time, Citibank was issuing a credit card out of South Dakota, which is a common state for banks to issue credit cards out of, as it has unlimited rates and fees. And in the facts of this case, we see here that one of the person's cards had a $15 late fee and the other had a $6 late fee. And these are after 15 or 25 days. So a bit of a different situation than we have today. But at this time, it was just the beginning of late fees being charged on credit cards, as it was thought that because interest accrues on your balance, a late fee wasn't needed on a credit card. So it was kind of controversial at this time to even charge a late fee on a credit card. And in fact, in California, it was considered unconscionable. So this California resident filed a class action, which is something that is common anytime you have a consumer dispute. If Citibank was charging Mr. Smiley a late charge, there were thousands, if not more, of other cardholders who were being charged the same late fee. And so it's very easy to bring a class action in a consumer context, since everyone is typically treated pretty much the same. So the question was whether or not the South Dakota law, which said the bank could charge any late fee it wanted, applied, or the California law applied. And here we had a California consumer and a South Dakota national bank. Well, during the time that this case started and winded its way all the way up to the U.S. Supreme Court, the OCC issued first a proposed regulation and finally adopted it, consistent with the Administrative Procedures Act, saying that the term interest, as used in 12 U.S.C. Section 85, which is the part that allows national banks to charge their home state rate of interest, includes any payment compensating the creditor for an extension of credit or making available a line of credit, which is in a sense what a credit card is, or any default or breach by a borrower of a condition upon which credit was extended. So basically any charge for extending credit or for breach or default. And that regulation went on to say that it includes, among other things, the periodic interest rate, the late fee, NSF fees imposed by the creditor, over limit fees, annual fees, cash advance fees, and membership fees. It does not include appraisal fees, commissions and premiums related to insurance, finder's fees, document prep fees, notary fees, or fees incurred to obtain credit reports. And so, as we know, the question becomes, is this sort of a rational regulation under the Chevron deference? And so I like to kind of put up this chart to list them out. So on the left here are the interest-like, we call them interest and interest-like fees. And on the other are the non-interest fees. And if you're trying to kind of decide how a fee gets in one category, I like to think that the fees on the left are kind of what the bank is making for extending the credit, And the fees on the right appear to be a bit more for something, an appraisal, a credit report, document prep. But anyway, taking this type of an approach, the US Supreme Court, applying Chevron deference, determined that the comptroller's interpretation was reasonable and therefore it was valid. And so in fact, that regulation and that list is how usury preemption is interpreted today. So it is not just the numerical interest rate, the percentage applied to the balance. It is also the interest-like fees, which, if you think about it, I guess one, it is true that high fees can be associated with an interest rate. I mean, the bottom line is it's what the creditor is making. But also that if it was only the interest rate, it does seem that it would be potentially less useful, but also maybe easier to manipulate or restrict. If the states wanted to restrict the banks, they could restrict the fees they could charge, and they would only be left with the interest. So we get to the place where we have the most favored lender doctrine from Tiffany, pick the best rate in your home state, the exportation doctrine from Marquette, charge it to consumers and borrowers in all states, and Smiley, that interest include the interest-like fees. And I would like to take a minute to talk about the handout in the OCC letter, just to maybe give a little minute to, how do you do this? Let's say you're the compliance professional and you want to charge some fees that weren't listed in the regulation. So I'm going to have to reshare here. Let's see if I can find it. Here we go. So I did include here as the handout. Let me go to the first page. So this is the first page of a letter to the OCC. And as you can see, this was the year after Smiley was decided. So a bank is asking, a national bank, that's why they're asking their regulator, the OCC, if these 5 fees are part of interest. And it's an account opening fee on a home equity. This is a home equity line of credit. That's a line of credit secured by the equity in your home. A fee for exercising a fixed rate option, a fee for prepaying a fixed rate option, a fee for early closure of the account, and rejected item fee imposed in a variety of situations. And so this is something that the lawyers and the compliance professionals might decide to do. There's some fees, they could make their own decision, or they could try to get the OCC to write a letter. And what you would do is you would write a letter, obviously, as the bank, saying all of these fees were interest and really asking for confirmation. So an account opening fee seems clearly like some of the fees that we saw in the credit card context, sort of the annual fee. So very easily, the OCC said that that was interest. Now, a fee for exercising a fixed rate option has to do with a home equity line of credit usually has a rate that varies with the market rates, but you can oftentimes make a large purchase, let's say a couple $1,000s, and for a fee, get a fixed rate on that portion. So let's say you had to buy a roof, you could take $10,000, buy your roof, and for a fee, get a current rate that wasn't going to vary. The OCC also found that to be interest. That was for extending the credit. It had to do with the rate. And as we know, there's something related by rates and fees. The next one was for prepaying a fixed rate option, which would mean, let's say you got a fixed rate for 3 years. And instead, after 1 year, you paid it off, you might have to pay a fee. And again, the OCC, well, that's interest-like because the bank was planning on a 3-year stream of payment and 3 years of interest. You paid off early, you have to pay a fee. And the next one, a fee for early closure of an account. That's really quite similar to a fee for prepaying a fixed rate option. You entered into an agreement to have a line of credit for, let's say, 10 years. After 5 years, you want to close it. If you have to pay a fee, again, That's the cost of the credit. So that again was found to be interest. So you may be seeing a pattern here that the OCC was very inclined to find things to be interest. Now, finally, on the rejected item fee, which seems very much like the NSF fee, the bounce check fee, the OCC said, well, it may be or may not be part of interest. They said after the account is closed, if there is a rejected item fee, that would not be part of interest because there's no longer a credit account. But as long as the credit account is opened, the fee is part of interest. So it gives you a pretty good idea that if you kind of name your fees right and you think about your fees, a lot of the fees can be within this bank preemption. And just quickly here on the handout, I also just gave you a copy of Section 85 and then also this 1831D or Section 521 that we're going to talk about in just a moment. So going back to our PowerPoint. Oh, you can click through these. I don't know. There we go. So that was kind of the situation. And it continues to be the situation today. It's one of the reasons national banks are so attractive for lending programs. But in 2015, we had a case that really sort of upset the bank and lending world. And as you may know, if you've ever taken out a mortgage loan in particular, banks oftentimes sell their loans. And in this Madden case, a bank had sold actually credit card receivables, which means it's not the account, it's just what's owed. And these were receivables basically that whoever owed on them, many thousands of people, were not paying. So they were unpaid receivables and they were essentially sold to a debt collector. And the debt collector was trying to collect on these unpaid receivables, and they were continuing to accrue interest. And the consumers filed a suit in New York and said, you're violating New York usury law and you're not a national bank debt collector, Midland Funding. And this was actually a debt collection action. This wasn't any highfalutin court action or big important case. It was a simple debt collection action. And it was just an attempt for the consumer to kind of stop the debt collector from collecting. And the court said, you're right, debt collector's not a national bank. They can't keep charging that interest. Well, this really sent shock waves through the entire banking industry and all the buyers and all the investors, because forever and ever, banks have sold their loans and the individuals and companies and investors who buy them continue to collect the interest. And there's always been this idea that a loan contract that's valid when made continues to be valid and can be collected according to its terms. And so there was quite a number of years of debate as to, it seemed that everyone agreed the case was wrong, but the case was still out there and it created a lot of anxiety. And it really devalued actually the value of bank loans in this particular circuit, the Second Circuit, which is the New York area. But fortunately in 2020, there was a Madden fix rule that makes it clear that interest on a loan that is permissible under 12 U.S.C. Section 85 shall not be affected by the sale, assignment, or other transfer of the loan. So although it was really controversial for quite some time, it is now once again settled that national bank preemption continues. And it isn't really that the preemption applies. That was actually in a part why Madden was decided wrongly, because it was described as the preemption continuing to apply, which is actually not true. The preemption only applies to the bank, but it is as a matter of contract law that a loan valid when made can be collected according to its original terms, even if it has been sold and is being collected by a different entity. So that was resolved. Going back to the reading and the issue of usury preemption, we've been focused on national banks for a couple of modules. But now we read the Greenwood Trust case, and this is what the Discover Bank was originally called, the Greenwood Trust Company, and it was a state chartered bank out of Delaware. Delaware is another state that is very popular for credit cards because of currently they have deregulated rates and fees, but back in the 1990s, they permitted a $10 late fee. Again, this is because it's the beginning of late fees on open-end credit, where Massachusetts law prohibit a late fee. We have the same situation. We have 100,000 cardholders living in Massachusetts being charged a $10 late fee by Discover Greenwood Trust. And we have a class action saying you are violating the law. And this is going on. If you look at the date, this is actually before Smiley. But what is really important about this case is not the fee question, but it's that the court looked at this section 521 of the Depository Institution Deregulation and Monetary Control Act of 1980, DIDA. And it said, in order to prevent discrimination, state chartered banks can charge interest, notwithstanding any state constitution or statute, which is hereby preempted. So this is the express preemption, at either that 1% in excess of the discount rate or the rate allowed by the laws of the state, territory, or district where the bank is located, whichever is greater. And so if you have that handout and you look at these, you see, one, it was enacted by Congress to prevent discrimination against state chartered banks. And two, it uses a lot of the same language as Section 85. And so because of that, the court had no trouble finding that Congress was trying to level the playing field between federal and state chartered banks. And we have express preemption. And basically, the outcome is that state chartered banks have this same preemption that we have been talking about for usury and the interest-like fees. And basically, it's what the court said and what other courts said as well, is that the FDIC bank provision should be construed the very same as the national bank preemption, that they were intended by Congress to mean the very same thing. And the reason that's very important is because the OCC was much more active and aggressive on issuing letters like the one we just looked at and guidance. And the OCC just has more authority. But because of Greenwood Trust and similar cases, an FDIC bank can rely on Tiffany and Marquette and Smiley and the OCC regulation and letters. The FDIC has actually recently adopted similar regulations, but for many years, there was really just national bank authority and a few cases saying state chartered banks can rely on the same. So what we end up with is national banks have the benefit of Barnett Bank preemption, but national banks and state chartered banks have the same usury preemption. So they're also a potential vehicle for a national loan program. Just to keep everything clear, I have said that state law regulates usury. There is an exception, and it was in one of the notes I asked you to look at, and that's the Military Lending Act. There is a federal law that does limit the rate on credit, and it's certain types of consumer credit. So things like mortgages, which you're never going to have a mortgage over 36%, and certain motor vehicle secured loans. But in general, in unsecured credit to members of the military, the rate is regulated by federal law at 36%. And it's a military annual percentage rate, which is a rate that pulls in certain fees, and actually more fees than the Truth in Lending Act, which we will talk about later. But other than this Military Lending Act, state law is the law that governs the rate of interest even on bank loans. And because that is kind of such a key part of, our state federal regulation, when the Consumer Financial Protection Bureau was created, it was expressly put into federal law that the CFPB could not establish any kind of usury limit. because this is, one of these kind of important points of state and federal law, that state law governs in general rates and fees on all loans, including bank loans. So as I kind of mentioned in the notes or during this part of the lecture, as one of the notes asked, we see South Dakota, Delaware, Utah. If you were to look at your credit cards, you would all likely see similar banks, because these are the banks that have unlimited rates and fees. I also asked you to read the note about the ILCs, and we talked about that the other day, and that'll come up again when we talk about bank holding companies. So I may hold off on talking about that, but just keep that in mind. So this is kind of the end of our usury preemption, but this is a very important issue for compliance professionals, because you see how a bank extending credit only has to look to its home state law, but it does have to determine what fees are interest like. So please let me know if you have any questions. Thank you.